I've been working personally within the community association field now. This is my 42nd year. Sal and John are also very experienced. Sal's been with me for over a decade. John was an experienced trial lawyer in New York and has been with us now going on to his 3rd year. And let me tell you what our firm doesn't do. We've been working for the last 25 years as this firm in the community association field. We don't do general counsel work. So we don't do document amendments. We don't tell you what the legislature did last year. We don't collect your money. We are construction lawyers working primarily within the realm of the community association field. Probably 70% of our work for the last 25 years has been in supporting condominium and homeowner associations on construction matters. And let me just describe what those are. We do a lot of turnover work. So for either condos or HOAs with multifamily buildings, we handle construction defect cases and accounting claims upon turnover. We advise homeowners associations that don't have multifamily product on going through turnover, their regulatory activities, SWIFT mud, compliance with county development orders. We are full-time negotiating with developers. Sometimes we're in court with them to try to get compensation for associations coming through turnover. We also are construction consultants for condos and HOAs who are undertaking major repair projects. So we do contracting work.
Alan, I think you either accidentally muted yourself or perhaps
Sorry.
Michelle.
Is that better?
Yeah, you're back.
Okay, sorry.
Repeat the last 7 seconds of what you said.
All right, well, on the repair project side, we offer consultation and so forth on undertaking projects. And then when those projects don't go well, we get involved at that point. So what we're going to do, and we want to make this a monthly effort, is we're going to do educational sessions on construction and repair issues involving homeowners associations and condominium associations. If you think about it, really the primary purpose why a homeowner association or a condominium association exists is for the maintenance and repair of the property that's under the jurisdiction of the association. In a condominium, it would be the common elements. In a homeowner association, it's the common grounds that are owned by the association. And where there's multifamily product, duplexes, triplexes, quads, sixplexes, eightplexes, you're talking about, in many cases, the maintenance and repair of some of the exterior elements of the building. But certainly there's a function of holding meetings and purchasing insurance, the safety of the membership. But the primary purpose that homeowner associations and condominium associations were established was for the purpose of maintenance and repair. So it is a central function for every association. What we're gonna cover in this first session is just a general overview of maintenance and repair in both condos and HOAs for the life cycle of property. And it starts with buildings that have come through turnover. We're going to talk about repair projects that may come in 10 or 15 years after the project's been in shape. And we're going to deal also with some older properties where the maintenance and repair needs are generally much more intensive, and the different approaches that groups can take in confronting it. But what I want to start with is the basics. What obliges a condominium association or a homeowner association to undertake repair? is there a statute? Does it come from the documents? And I'm going to ask my partner Salvatore Scro to talk about condos first. Sal, what is it that actually requires that a condominium board administer the repair and maintenance of a condominium project?
Well, most of you, if not all of you, are probably already familiar with the Florida Statute 718.111 that provides what the condo association is responsible for, and not only what they're responsible for, but what they must do. So a lot of times these questions come up, as far as we see, for the most part, when there's something of significance that has to be done. The day-to-day stuff, I'm sure you're all aware of, but when there's something of significance, that's when the question arises, what's our responsibility? So that statute in Section 1A states that the operation of the condominium shall be by the association. It also states that the officers and directors of the association have a fiduciary relationship to the unit owners. So that's very important. The fiduciary relationship, that word fiduciary means a lot. It means that you have a position of trust, that the owners have the right to have the confidence that you're going to do what's best, not for them personally, but for them as unit owners, not as unit sellers, not as unit buyers, but as unit owners. A lot of times you will come out and hear, well, I don't want to engage in this because now it's going to deplete the value of my property. Or most recently, we've gotten a lot of phone calls from lenders that ask about, well, what's going on with this project? Are we going to be able to lend money? Can you tell me what's happening? So your unit owners under the statute are identified as shareholders or members of the association. So you as board members have that fiduciary duty to them. That statute goes on in a subsection C, and this is, it states that a unit owner does not have any authority to act for the association by reason of being a unit owner. So this law makes an already important fiduciary duty that I just mentioned to you even more important, because they cannot act on their own. In fact, there's some case law that talks about that. I know my partner Alan had a case that you may have heard about here in Sarasota, which dealt with ramifications of a board shirking their fiduciary duty to maintain the condominium. Alan, actually, since I brought that up, take a couple seconds or minutes and just explain what that means when the board does not act on behalf of the association.
Well, you have a combination of an obligation under the statute for the board to maintain the common elements and a prescription against an owner undertaking self-help. So a pretty obvious thing in the condominium regime is if there's a common element roof that's leaking, or a plumbing lateral that's backed up that's causing plumbing backup into the unit, an owner, because of 718.111.1C, can't undertake self-help. They can't contact a roofer to come out and fix the roof or patch the roof. They can't call a plumber out to do modifications to a plumbing lateral that may be entering the building. So they're totally at the mercy of the association. And here you have the board with its fiduciary obligation. So it does put the board into a heightened degree of responsibility, both because of the fiduciary element, but because the owner has no way of undertaking self-help.
So so what happens, Alan, if the board, what happens, but what could happen if the board does not perform repairs that they're responsible for, or that they shirk their duties? What risk is that to the board members?
Well, there's a very important statute, is under the Condo Act is 718-303. There's a corollary section in the Homeowners Association Act, which is 720-305, I believe. And that says that if the board doesn't act, an owner can go into court, get an injunction to require the board to undertake the repair, or they can get damages for what they suffered. And there's a case called Coronado. Anyone who's interested, we could send it to them. But Coronado was a plumbing backup case. The board didn't correct the common element plumbing problems. There was actually sewage that backed up into the unit. The owner fell ill. They had to vacate the unit. And there was a substantial judgment against the association for failure to take action. So, so I think there's a section also in the Condominium Act that you might want to touch on that actually makes the association responsible directly for the maintenance of the common elements. I think that's 718-113-1, correct?
Right. Yes, and there is some additional information I wanted to give you about 718-111. That section 3 provides that the powers of the association include, and they aren't limited to, but they include the maintenance. It also includes the management operation of the condominium. We know that, but it gives the association the power to make and collect assessments regarding the maintenance of the condominium, and it gives the association the power to perform the maintenance, to perform the repairs, to arrange for replacements of common elements. And then there's another important section there, which is section 5A. And a lot of times you have to deal with going into the units to perform repairs, maintenance, preventative maintenance. That section gives the association, and this is the word in the statute, an irrevocable right of access to each unit. So that cannot be revoked. The purpose, though, is not just any right to access the unit. It's during reasonable hours, and the other important words are when necessary. So necessary is an important word for maintenance, repair, or replacement of any common elements, or any portion that's to be maintained by the association. So if there's a part in the declaration that says that the board is responsible to maintain certain portions of the condominium, then you have the right to access to maintain those, or you have the irrevocable right of access as necessary to prevent damage to the common elements or to a unit. So if there's something that you're aware of that is arising that could create damage to a unit or to the common elements, then that's something that you have the authority under that statute. The statute Alan was just mentioning, 718-113, addresses, among other things, the maintenance of the condominium. Section 1 of that 718.113 states that maintenance of the common elements is a responsibility of the association. So the word, as attorneys, we look at words. Some of you may have remembered that the word was an important word. Well, the word responsibility is an important word. It's the responsibility, the maintenance is the responsibility of the association. It's not an option. And the next area that dictates the fiduciary responsibility of the board to maintain the property is also found in the Declaration of Condominium. So in the declaration, you want to be familiar with that. You want to read it thoroughly. Usually there's a complete section on maintenance. There's a complete section on powers and responsibilities. So be sure to always read through that. Don't forget to look at amendments. They're important. So don't just read the main body. Check and see if there's any amendments to those declarations. But I think that pretty much completes it on the responsibility of maintenance for condominium. I think we're probably going to go on and talk about homeowners associations. Right, Alan?
Yes. Now, before we get off of that, I want to have one comment about that right of access. And it's a big question among condominium practitioners as to what kind of responsibility or liability does that create on the part of the board. So let's take a high-rise building. An owner reports that their ceiling, all of a sudden there's a big water stain in the ceiling. And What happens sometimes is owners go away. You may have a hot water heater that clogs and the pan's overflowing. The owner's on a safari in Africa, and it's causing not only damage to the common element, but damage to the units below. It could be another type of plumbing problem that exists, an overflowing toilet. The statute gives the right of access, and what does a building manager or board do when they get a phone call from owners maybe 2 floors down about this water leakage problem? And I would say that 1718-111-5, which is the right of access, probably creates an obligation on the part of the association and management to take action under those circumstances. Some associations have a very thorough key system where they have keys to access to all the units. Some of them don't. Certainly make an attempt to contact the owner, but I think it's an obligation, or could be construed as an obligation on the part of the association to get into that unit to stop the source of the leakage. Because remember, the statute says that it's a right of access not only to protect the common elements, but also other units. And that owner in a unit below can say, I absorb substantial damage as a result of the board or the management not acting under those circumstances. So sometimes a right of access creates an obligation, and I think there's an argument that a group would have. So I want to turn to homeowners associations, and as construction lawyers, we actually have in mind 2 different types of homeowners associations. There's a homeowners associations where the only type of residential construction in the property are single family homes, where each homeowner has an obligation to maintain and repair their particular home, and the association is only responsible for the common areas that are owned by the association, the roadways, the drainage areas, the clubhouse, the swimming pool, tennis courts, entrance, and so forth. But there is a fairly new product on the market, maybe not that new, but developers decided to start building multifamily buildings under an HOA regime. So there's full projects that are all 6-plexes and 8-plexes. They're not condos, they're under the HOA regime, with the association having some maintenance and repair responsibility over the exteriors. Now we've seen some product recently where you'll have a project that's a mix of single family homes and duplexes or triplexes and quads, create some interesting anomalies relative to maintenance and repair responsibilities. And I'm going to ask my partner, John Lamole, to talk about where the maintenance and repair responsibility comes from, what the genesis of for homeowners associations, and what are the particular challenges from a documentary standpoint as to the multifamily product that may exist within those communities. John, you're on.
I'm glad you gave me this as opposed to giving me Sal's topic, because I don't have to spend a lot of time talking about statutes, because the big difference between a condominium association and a homeowners association regarding authority for or the obligation for maintenance and repair is that in a homeowners association, it's almost completely document driven. And so the authority for the association's obligation to maintain and repair common areas in a homeowners association is going to be in the declaration of covenants and restrictions. And that's really where you need to be looking for what the association's responsibility is going to be. As Alan said, in a typical single family homeowners association, that's pretty clear. I mean, you know, the homeowner has responsibility for the home, and the association may have responsibility for a lot of other things like irrigation and roads and drainage and landscaping and all of that. But when you start to get into these mixed types of communities where you have single family homes and multifamily buildings, or you have just a community of entirely multifamily buildings, you can never assume that the developer and their lawyer has clearly delineated or even rationally delineated what the, you know, where the limits of the association's maintenance and repair obligations lie. As a practitioner, I've seen, you know, very detailed documents and documents which were very vague and ambiguous. And the vague and ambiguous ones create some problems because there may be, for example, an association may have the obligation to replace the roofs, but it may not speak to things like the roof framing, if the roof framing underneath is damaged because of water intrusion, because, you know, the shingles and the underlayment either had a defect or over the passage of time. You know, there have been situations where associations in multifamily buildings have you know, created situations where the owners have had to replace, or there may have been, you know, scatter shot or partial replacements of roofs on a multifamily building, and then you have some aesthetic problems. So I always like to give practical tips. And if you're a board member or a manager of an association that has multifamily buildings, and especially right around turnover, when you have an opportunity to look at these documents, that's a great time to take a really good hard look at what the association's maintenance and repair obligations are. And if there are opportunities to make that obligation clearer and more reasonable, more rational, certainly the association should consider taking that.
John, let's talk about some specific issues. So, you know, we've confronted multifamily buildings under the HOA regime where maybe they have responsibility over the roof, but the only thing, the responsibility on exterior walls is like painting. And then you have a project where you have a duplex or a quad or a sixplex that has stucco cracking. I've never been able to figure out on a sixplex how it would be that the 6 individual owners would be able to repair their stucco or their windows in a fashion to protect the other owners. So discuss kind of an anomaly like that.
Well, you know, water's a funny thing. Water intrusion's a funny thing. You never know where it's going to wind up. And so you always have to be mindful of those situations where, you know, if an owner has an opportunity to maintain some portion of the building envelope and they don't do that, and that failure creates a problem for another owner. You know, now you have a situation that's a little bit difficult for the association because who's responsible for taking care of that and who bears the cost of doing that. So, you know, those are the types of situations where it really pays to take a good hard look at the governing documents with an eye towards what are the possibilities that can arise from either defects in the original construction or failure of failures to maintain certain aspects of key components like the building envelope. Who's got responsibility for those things and who should have responsibility for those things to lessen the risk, to minimize the risk to the association. And that's really what this is all about. It's an opportunity for the board and the association to control its risk.
Well, here's the to edify what John's indicating. Here's the practical reality. If you have a sixplex or an eightplex and it's under the condominium regime, it's very clear what's a common element, where the condominium association's responsibility is. So if you have an eightplex that's under a condominium regime, built in both by the Condominium Act and under the documents, the association is going to have responsibility over the exterior walls, the structural components, the roofing. If there's a problem, the association is going to come in and act. When you have an eightplex that's under a homeowner association regime, it's governed by what the documents indicate the association's level of responsibility is. And for prudent management and operation and maintenance of a multifamily building under the HOA regime, it takes a thorough review of the documents to create an intelligent approach. And there's another aspect of it. And the other aspect of it is if an association is going to pursue defect claims on a multifamily product under the HOA regime, the rule of procedure says in order to do that as a class action, the association has to have the maintenance responsibility. So that's another factor in amending the document. So what we've spent a half hour on, and for those of you who have worked in the field for quite a long time or have been operating your association, maybe none of that was new, but sometimes it's good to have a reminder about where the repair and maintenance responsibility comes from. So let's get into the guts of maintenance and repair approach.
Hey, Alan.
Yes.
Can I ask you one question before you move on? Because I actually live in one of those HOAs that has the quads, where you don't necessarily share a wall because your garage is in between each, but you do share the roof.
Yes.
And we did have a situation where one owner had termites in the wood roofing, and unfortunately those termites started eating into the neighbor's roof. Like however they got there, I don't know, but started happening. So now, because we as the HOA cover roofs, internally that was the issue of the owner not treating his home because we only cover subterranean termites. But is that owner then responsible for, given that he didn't treat his home because he didn't want to use pesticides to do so, he didn't believe in that, would the other owners hold him responsible because that's not something the HOA covers?
One of the undecided issues, if you're pointing out one, is what the liability as the owners are.
Correct.
Yes, there is a possibility of liability there, but again, it's something that should be really cleared up in the documents going forward. So
if it's not cleared up, that's something we should actually put in as
yes.
not an amendment or something along those lines, correct? Given that we've had that problem and now we didn't know how to deal with it.
Absolutely.
Okay, good to know. Thank you.
Good. Okay. So
let me hang on. There's a question in the chat as well, Alan, and I think it was it was sent only to me, and so everybody may not be able to see it. So let me just throw it out there. The question is I think what he means is a multi-family unit where HOA has exterior responsibility. To what extent is the HOA's responsibility for interior damages as a result of exterior damage? So that's the classic case where the HOA is charged with maintaining the building exteriors, the stucco, the waterproofing. They don't, for some reason, or maybe despite their maintenance, there's water intrusion that affects a person's individual unit within that building. And I think there's differing opinions on that and differing and conflicting thoughts, but what is your take on that, Alan?
well, this would apply to condos and HOAs. If it's really a negligence standard. So, for instance, the first time there might be a water intrusion issue where the HOA or condo has maintenance responsibility over the exterior. They correct the situation. There's a strong argument that the association is not liable for that interior damage. The homeowner should go to their own insurance carrier. If there's been a repair that's been neglected for some time, the association didn't act to undertake the common element repair, you get into a more difficult situation where an owner could pursue the association for negligent maintenance. So it really depends on the factual background as to whether there's responsibility. But it's not strict liability. It's not an issue where just because there's interior damage that's caused by a common element defect, the association is obligated to respond to that damage. It would generally fall back to the unit owner or the lot owner initially. But let's get into the second segment, which is particular maintenance and repair issues that are based upon the lifestyle. And Sal, why don't you talk about the specific maintenance and repair challenges that affect, let's say, a condominium group coming through turnover?
Thank you for giving me that one, because that's something I'm very passionate about. Why? Because I see things after they've already been started, after they've already been done. People come to us with questions and concerns, and it's like, why didn't you talk to us sooner? So for new condominiums, and even those that are under 10 years old or have had questionable repair work within the last 10 years, you have to really listen up to this one. So it'd be nice if every condominium building or townhome or single family home came with a check engine light or maybe a check building light, but they don't. And even if they did come on, what does it mean? You're driving down the road, your check engine light comes on. That's all it says, a check engine. You don't really know. And you don't know with your buildings either. So also, especially for new condominiums or something where work was just done, the looks can be deceiving. You know, a savvy developer, they want to sell units. They want to make it look as appealing as possible. You see it in the brochures and everything else. So how does a condominium owner, or even a homeowners association for that matter, know if there's any defects in the construction of the common elements of the improvements? The answer is a really long one, and I'll give it to you right now. You ask. All you do is ask. And who do you ask? That's the question. Who do you ask? So the best way for the association to find the answers to the question of that we just posed is, in our opinion, you ask a qualified forensic engineer. And a lot of people hear, when they hear qualified forensic engineer, they hear money. That's not always the case. Sometimes there can be visual inspections, things. There's ways to go about things. So selecting the best engineer, though, isn't easy. Definitely do not select your engineer based on who the lowest bidder is. Bad news. And it's also not a good idea for the association board to take on the selection process on their own. I recommend against that. I know that that boards are made up and managers are made up of highly intelligent people, highly successful people, highly motivated people, or you wouldn't take on that responsibility, because it certainly isn't fun. I'm sure you all know that. But I still don't recommend you take it on alone. Everybody has their role to play in the world, and this is one where I say you need to ask first an experienced construction and defect attorney. Who that attorney would recommend is an engineer to take on the investigation of the common elements of the property. The construction defect attorney, they can identify the engineer who they believe, and it's based on experience with various engineers over the years of practice, who that engineer would be to best serve the condominium association or HOA to investigate the type of construction. Is it roof? Is it stucco? Is it windows, roads, drainage issues, whatever it may be? And identify they would know who that engineer would be to identify the defects and the code violations in the construction, to prepare a detailed written report with relevant photos of the defective conditions, and if necessary, serve as an expert witness in any action to recover for the defects. You do not want somebody out there doing all this work, coming up with opinions, and then sit there and in a deposition or a trial that they're boring. I hope I'm not boring. Or putting people to sleep. You want someone who can communicate clearly and in simple terms. And you also want, and how are you going to do this by just looking at the bids? How are you going to know what questions to ask? How are you going to know that the answers are going to be something that have already been determined whether or not this is the best engineer. Well, we know that. So the best engineer, the best expert will not qualify as answers, and they're not so that they don't offend who they believe might be their next client. They're not afraid to take a clear position and point fingers at the potentially liable party. You want someone who is ready to point their finger at someone and say, you're responsible for this and you need to take care of it. So that's what you want in a good engineer. Now, the wrong engineer can be, and usually is, a case killer. It's a waste of association funds. So you want to make sure that you select the right engineer. So you go to the first people, you ask questions. You ask the construction defect attorney, who would you recommend? And then those questions go on to the engineer. What do we need to look at? So the forensic engineer, they can usually identify what we don't see by just a visual inspection. They can walk through, they can see things that the average person wouldn't recognize. So, for example, cracking stucco. It's not always a stucco problem. It may not be a stucco problem at all. You, as board members, as managers, you see, I have stucco cracking. I have a window leaking. I have a window leaking. I have a window problem. I have stucco cracking. I have a stucco problem. That may not be the case. It may be that your window leak is a result of a roof problem. It may be that your stucco cracking is a result of a window leak. So you don't know what those are until you have someone look through. So I've come out with engineers and walked projects several times. They've walked through, they've looked and said, you know, I took an engineer to 2 projects on the same day. One all wood frame, one all block. I expected this wood frame building would be the biggest problem. He walked through, he said, not a problem. We didn't spend any money, we didn't spend any time. Looks okay. We walked through the block constructed building, and he says, this one has this problem, that problem, that problem. They can identify these things. So the things that we wouldn't see, they identify. So don't rely upon what you're looking at. Use somebody that's qualified to look through these things and find out what it is. So what happens if the areas of construction appear to be defective in the opinion of the engineer? Then what do you do? A lot of times what happens and should happen, and we recommend, is that you do a more intrusive investigation into the building. That's where the engineer deconstructs portions of the building in like a peel the onion fashion, and they reveal the manner of construction to see if it was properly or improperly constructed, as well as to reveal any hidden damage. This is sometimes it's referred to as destructive testing, destructive investigation. Alan, I'm going to use one of your metaphors or whatever it is, similarities. You don't go into the surgeon and say, cut me open and fix everything. You need to, I'll let you say it because you probably say it better.
Well, look, I go back to, where we started, which is the fiduciary obligation. So a turnover of a new project, the board's got the maintenance and repair responsibility. And how is it that you know what to do to undertake that responsibility unless you have a thorough knowledge of the building? And all you're seeing upon viewing the building is the exterior facade. And one example was a project we had up in Pasco County, where, as you said, there was stucco cracking. There were 6 plexes and 8 plexes. And the developer offered to do waterproofing. Well, it turned out when they got into the building structure, they cut in through the sheathing. It was determined that there was a major framing problem at the second floors. And what really needed to happen was a framing repair, removal of all the stucco on the second floor, and that's in the end what took care of the problem. So that's the reason. A couple of reasons to do that type of investigation is, number one, there may be potential claims, but also so that the association can plan long-term for its repair and maintenance and reserve responsibilities.
One of the other things that is very important, in my opinion, is to have the construction defect attorney involved early on and throughout the engineer's investigation. Why? We find that we can assist in what information is necessary for the engineer to obtain to support any action to recover for defective conditions. The questions that are asked throughout any action to recover for construction defects, you would not believe. And some of the first things they ask is, how did you select what you wanted to test? Well, the right way to do these things is the way they do it is they go through, they do a visual inspection, they make a hypothesis, and then they do the testing to reveal and determine whether their hypothesis is correct. But then you have to extrapolate that and say, is this something that applies to just that area, to the entire project? So you cannot just rely upon one area. And a lot of times what happens is if you spend all this money on an engineer, or a lot of times engineers will piecemeal you and say, well, first we're going to do this, and then we're going to do this, and this is going to cost you more or whatever. You want the attorney to coordinate things so that it's the most effective, most efficient, gets you the information you need. I was out at a destructive testing on a project, and we revealed all these problem areas, rot underneath, that you did not see. The project looked beautiful. They walk through, they say, oh, this diverter, which is a little piece of metal that kicks water out from the roof where it connects to the stucco. This diverter's installed wrong. We open it up, rot all the way down the building. Now, after we investigate some of the buildings where we know there's leaks, I'm saying, okay, let's go through and pick out the nicest looking building here. None that's never had any problems. And let's look at that. Why? Because that's going to support our case. That's going to get the association the most money. So it's important that not only the engineer can go through and say, oh, yeah, I think this is a problem, and then they're going to test and say, see, I was right. But that doesn't make you, that doesn't put you in a position to recover what you need to recover. So selecting a good construction defect attorney who brings a good forensic engineer who can serve to accomplish what we discussed, that usually facilitates, and we find that to be the case in our cases we handle all the time, that usually facilitates a beneficial settlement for the association without having to go to trial. Now, opposed to that, the wrong team can lose your case before it ever sees the light of day. So, and the problem with that is that leaves the association members or the owners to pay to correct all the defective conditions, which could run several millions of dollars in some cases. The other reason you want to use a good engineering company is for reserve studies. You want to determine the remaining useful life, the repair, the replacement estimate, and identify what may need to be put into reserves to accomplish the repair or replacement when that time comes.
All right, John, can you deal with homeowner association turnover? What are the things that homeowners associations should be looking to investigate outside of the multifamily building issues?
Yeah, well, first of all, a lot of what Sal said, maybe all of what Sal said is equally applicable to homeowners associations. But, you know, folks, turnover is an opportunity for the owner members who may come from various walks of life. You know, your board may be, you know, you may have an accountant, you may have a retired teacher, you may have, you know, a small business owner who are suddenly coming into possession of the responsibility for budgeting and maintaining millions and millions of dollars of capital infrastructure, roads, drainage systems, ponds, lift stations, landscaping, you know, and areas, for example, like ponds and wetlands buffers that have significant regulatory environments that need to be complied with, and buildings, you know, and especially in the case of multifamily buildings, depending upon the governing documents, you know, there are responsibility for stucco, exteriors, roofs, windows, waterproofing, all of these areas that can create a lot of problems if you don't take care of them correctly. So turnover is a great opportunity for these folks who are just, you know, coming into the governance of this association to do their due diligence. just as if you would buy a business, you would do your due diligence before closing on that business. Similarly, a post-turnover board should be thinking about due diligence in terms of understanding what the condition of their common areas and components that they're responsible for maintaining, what the conditions of those are. And as Sal said, in our experience, when we have problems or when we come across issues relating to construction, they're never patent, they're never open and obvious. They're always something that was there that you didn't know about and kind of festered for years, and then finally 5, 6, 7 years later came to light. Well, wouldn't it be great if you had the ability to know that those problems may exist, way earlier than 7 years later, when all of a sudden you've got stucco failing and water intrusion problems? Wouldn't it have been great to know what really is the useful life of these? And everybody gets reserve studies, and I understand that, but you get an engineer in there to do a really good investigation of your systems and components. They're going to be able to give you a really great assessment of what's the useful life, what are the maintenance and repair obligations that I'm facing in the next few years, where the defects are that may not be readily observable. And I always think in terms of risk management. I was an economics minor in college. And so for me, I always speak in terms of risk management. You always want to manage your risk, and you want to offload as much risk as you can to somebody else. So put it off on an engineer. Let him tell you what may be wrong with your building, and get a construction attorney involved very early on so that you bring the right engineer to the table. You can look at the right places, and then with that information, you can make smart decisions about budgeting, reserves, whether there are problems that we may want to seek compensation for. We don't want to leave money on the table. If the developer left us with a pig in a poke, let's do something about it. And let's do it now before it's too late. So to get back to the question, it's a long kind of circular way of answering Alan's question. At turnover, it really pays to have an engineer come in and look at roads, other site improvements, ponds, drainage systems. It pays to have somebody do an engineering investigation of building exteriors, roofs, stucco, waterproofing, balconies. Those are all key areas where if you have a defect that shows up 5 or 6 or 7 years later, it's going to be a major problem. And then the other key area to be looking at is, again, going back to the governing documents. What do our governing documents require us to do as opposed to what they should say we should do? And do we need to make any changes? And that's where a construction attorney can be really key, because we're in the trenches. We know where the problems can be. And if your governing documents don't allow you to do certain types of investigations because you don't have maintenance and repair responsibility for those areas, that's an opportunity for you to go back and revise your governing documents to allow you to do the kind of due diligence that really should be done at turnover. So it's a twofold thing. It's looking at doing the right investigations, and it's also making sure that documents say you can do those investigations, investigate those areas on behalf of the association, and then also giving the association the ability to effectively manage the risks of future problems with their infrastructure and their buildings.
All right, John, let me tie a couple of things up, because we're getting within the last 7 or 8 minutes of our time limit. And for homeowners associations, any managers or boards, if you've recently gone through turnover, a big key is to look at the development order that may have been issued by the county or a local authority to make sure that all the compliance issues have been taken care of by the developer. Sometimes there's a completion bond that you could make use of, that you should look into. A lot of times there's water management district issues. go and visit, for instance, the Southwest Florida Water Management District or your local water management district to find out what the compliance issues may be, because the developer may try to push some of those off on the homeowners association. So be aware of those, and be aware of time limitations. In Florida, there's a statute of repose of 10 years, which is the last possible date in order to undertake a claim for a defect. For condos, there's warranty limitations. We're not going to go through those all today, but there are time periods that you should be cognizant of. But let me tell you where we're going to go from here, because this was the initial session that we had, and we'll get into your specific questions offline if we can't get to them today. But we're going to talk about maintenance and repair issues, how to undertake appropriate steps in preparing for a major repair project. We're going to talk about the challenges of older condominiums. We're going to do that in a separate session. We're going to listen to the type of things that you're asking questions about and tailor future sessions as we go each month to deal with some of those issues. We're going to talk about reserves. We're going to talk about financing. So, what we've talked a lot about today was your responsibility. But the question is, how do you pay for it? And reserves is one way in order to plan for the future. There's special assessments that can be undertaken to cover building issues. We've spent some time today on recovery from third parties, such as the developer, which basically in the end ends up being a financing issue because the repair responsibility is there. And collecting from a third party is one way to undertake those particular functions. So we're going to be getting into those issues. I see there's a question: if sewage backup is excluded under most homeowners policy, is a condo association then responsible for backups, or should the owner have purchased the extra coverage? I'm not going to try to attack that particular question, and in fact, some of it I would rely on general counsel. So for Robert King, I'm going to get back and answer that separately. But let me tie together where our services lie within the whole realm of the maintenance and repair issue. If you're coming through turnover, we're very happy to consult with management or the board on turnover approach. We have had a policy of meeting with boards gratis to educate them on the whole turnover process. If you're undertaking a major repair project, contact us about approaches, about investigation. And one of the things we've seen as a prelude to some future discussion is we have seen groups enter into repair contracts before they actually have analyzed what's really wrong with the building. An example would be, you're getting leakage through a window system. And the presumption is, well, we need to either replace the windows or caulk the windows. It really can be a roof problem or a stucco problem where the water is actually gravitating down and coming through the window system, and it's not really a window problem at all. So there's a real importance as far as the investigatory phase of even a major repair project. And some of the principles that apply to new construction, as far as the level of investigation, would apply to a re-roofing project on a 20-year-old building or a 30-year-old building. So we're going to get into those that type of subject matter in future sessions for those of you who are managing and governing some older properties. And we are going to talk about condo termination too as a possibility, where you have a 40 or 50-year-old building that has major issues. So we will cover that. If there's any other questions at this point, we can answer them in the few minutes that we have left.
You can unmute yourself if you'd like to ask a question directly to the
Yeah.
attorneys.
Ann says, do we have a schedule? We're going to do these monthly. Somebody asked whether we could have exhibits. We will do some PowerPoint. I know my partner Salvatore Scro is a big PowerPoint proponent, so we're going to do that for future sessions. If you have any questions, if you think of something in an hour that you want to ask, shoot us a question. We'll be happy to respond to it. Sometimes we'll refer you to general counsel for the areas that are more within their expertise. I hope everybody has found some value in what we were able to present today. This is the first one. We're going to get into, like I said, specific topics for each month. We will be publishing a schedule. And I want to thank everybody for participating. Great job by my partner, Salvatore Scro and John Lamole, on the areas that they covered. And thanks to Michelle Colburn, who arranged this and set this up and handled all the logistical issues behind the scenes in order for us to put this forward. And
One more thing, Alan. I'm going to be sending
Yes.
out a evaluation form or survey, so I'd really appreciate if you all could fill it out and send it back to me, because that will just help us improve and get better as each one of these panels go forward.
all right, Michelle is going to send out an evaluation form and tell us what you liked, what you didn't like, where we can improve this. And for Robert King, we will provide you with that Coronado decision. And we'll stay on for a few minutes if anybody has any questions, but we've hit noon, we've covered our hour. So anybody has any additional questions, we'd be happy to answer in the next couple of minutes. Otherwise, we've reached the end of our presentation. Any other questions? Okay.
Thank you all for tuning in. We appreciate it.
Thanks, everybody.
So we have offices in Orlando and St. Pete and Fort Myers and Sarasota. That's our basic market. So we look forward to hearing from everybody. Thank you. We'll give some clarifications on the time. The next session will be. Thank you. Michelle, are you going to close us down?